Welcome back to this explainer from the Law Simplified series. Whether you're a law student, a practicing lawyer, or just a common citizen, today we're tackling a totally practical, absolutely crucial area of Pakistani criminal law: bail after arrest. When someone gets arrested, the panic sets in immediately, right? Families are terrified, the stakes are sky high, and literally the very first question on everyone's mind is, can we get bail? So today we're breaking down the source material to give you a clear, empowering legal toolkit that focuses entirely on Section 497 of the Code of Criminal Procedure, or CrPC. Okay, let's dive right into this. Look, being arrested is an inherently terrifying experience, but knowing your constitutional rights, that transforms raw panic into an informed legal strategy. It shifts you from a place of just being afraid to a place of action. The source material maps out exactly how the law balances the state's power to arrest with your fundamental constitutional right to liberty. So here's our roadmap for this explainer. We're going to cover 1. The rule of bail, 2. Decoding Section 497, 3. Exceptions and protections, 4. The judge's calculus, 5. The mechanics of release, and finally, number 6. The cancellation of bail. We've got a lot to cover, so let's get into it. Section 1. The rule of bail, the foundation of freedom. And this brilliantly illustrates the bedrock of our entire system, rooted in Article 9 of the Constitution of Pakistan, which is all about your right to liberty. The core philosophy here is actually pretty simple. In the landmark 2010 case of Tariq Basra versus the state, the Supreme Court spelled it out perfectly. Bail is the rule, jail is the exception. You are presumed innocent until proven guilty. Locking someone up before a trial is a massive deprivation of liberty. So because of that, the prosecution has to strictly justify why someone needs to be kept in jail. It's not on the accused to prove why they should be let out. Now, the text draws a really critical distinction here, and it's all based on the classification of the offense. If you're charged with a bailable offense, that's under Section 496 of the CrPC, bail is your absolute right. The law says the accused shall be released. The court has no discretion to say no. But if you're hit with a non-bailable offense, you're pushed into Section 497 territory. And here, bail is no longer automatic. It becomes a matter of judicial calculus. The judge has to decide. Section 2, decoding Section 497, the general rule and the prohibition. So the crucial point is this. Section 497 is the central battleground in Pakistani criminal courts for non-bailable offenses. This is where the actual fight for freedom happens. But there's a statutory prohibition right at the top, in subsection 1. While the law allows courts to grant bail for non-bailable cases, it explicitly says that bail shall not be granted if there appear to be reasonable grounds for believing the accused is guilty of an offense punishable with death or life imprisonment. If you're facing a capital charge, this is a massive legal hurdle. But you might be wondering, how does a judge actually decide if there are reasonable grounds when the trial hasn't even happened yet? Well, the courts do what's called a tentative assessment. They aren't running a mini-trial, but they are weighing the nature and quality of the evidence. For example, looking at the 2018 Supreme Court case of Mohammed Bashir, just a bare allegation in an FIR, a first information report, isn't enough to refuse bail. The judge is looking for a promptly lodged report, credible eyewitnesses, and actual corroborating medical or forensic proof. If that stuff is missing, those reasonable grounds might just fall apart. Section 3. Exceptions and protections, the humanitarian lifelines of Section 497-2. Now, what's really interesting here is that even when you're facing severe capital charges where bail is generally blocked, the law has these built-in humanitarian lifelines under Section 497, subsection 2. It carves out 4 specific categories that completely bypass that harsh general rule. If the accused is under 16, a woman, genuinely sick or infirm, or, and this is a big one, if there are simply insufficient grounds to believe they're guilty, the court can grant bail. Yes, even in death penalty or life imprisonment cases. Let's zoom in on that first exception. The number 16 is absolutely critical. Reinforced by the Juvenile Justice System Act 2018, if the accused was under 16 years old at the time of the alleged offense, they are legally entitled to bail. The only real caveat here is making sure their own welfare and safety are considered. Similarly, the law acts as a kind of superpower shield for female accused. In the 2015 Supreme Court precedent of Shamim Bibi, the court made it crystal clear. Even a woman accused of murder is entitled to the benefit of Section 497-2. This isn't a loophole. It exists specifically to protect women from the extreme physical and social hardships of pretrial imprisonment. And then, beyond those specific demographics, we have the concept of statutory bail. According to the Supreme Court ruling in Azhar Iqbal versus the state, keeping someone locked up indefinitely while their trial just drags on and on is unacceptable. If an accused spends years in pretrial detention without a conviction, that essentially turns into premature punishment, and the courts reject that. In cases of prolonged, unjustified delay, courts strongly favor granting bail.
Section 4. The judge's calculus. How courts decide bail.
So, when a judge actually does have the discretion, how exactly do they make the call? The sources outline a very specific three-pronged bail test from the Shaukat Hayat case. The judge is weighing three things. First, that tentative assessment of the evidence we talked about. Second, the nature and gravity of the offense itself. And third, the risk. Is the accused going to flee or tamper with witnesses? These factors are all tangled together. For instance, a super weak, uncorroborated prosecution case can actually outweigh a really grave charge. But on the flip side, if you have no fixed address and a history of threatening witnesses, you might be denied bail even on a much lesser charge.
Let's move to how this builds procedurally. You have to follow a strict hierarchy. You can't just walk into the Supreme Court on day one and demand bail. You step logically through sequential forums. You always start at the trial court, so either the judicial magistrate or the Court of Sessions. If you get a no there, you move up and appeal to the High Court. If they also refuse, your absolute final stop is the Supreme Court.
Section 5. Mechanics of release, bail bonds, and surety. Okay, let's say the judge slams the gavel and says bail granted. You might think it's time to just walk out the front door, right? Actually, scratch that. The fight isn't quite over. To actually get out of jail, you have to execute a bail bond under Section 499 of the CrPC. And this isn't just routine paperwork. It is a legally binding contract. The accused, and usually their sureties, promise in writing that they will show up for trial and follow all court conditions. Break that promise, and you're looking at serious financial penalties through the forfeiture of that bond money. Now, the court can ask for different types of security to back up that bond. A personal bond or owned bond is just a written promise without a surety, which happens a lot in bailable cases. But for non-bailable offenses, it's way stricter. Courts usually demand cash surety, where you deposit actual money with the court, or property surety, where unencumbered real estate is put up as collateral. Occasionally, for really well-known community figures, a personal security or recognitions will do the trick. So who provides the security? A surety. This is someone who formally guarantees that the accused is going to show up to court. But listen, the court is incredibly strict about who qualifies for this. The surety has to have the actual verifiable financial means to cover the bond amount. And the law is clear. Minors, co-accused in the exact same case, or people who are already out on bail themselves are absolutely disqualified from standing as a surety. Section 6. Cancellation of bail. Section 497(5) CrPC. It is vital to understand that getting bail doesn't mean you're permanently in the clear. The law has very clear, neutral safeguards to stop people from abusing the process. Bail can be canceled if the accused misuses their freedom, like tampering with evidence or intimidating witnesses. It can be revoked if they abscond, break their travel conditions, or go out and commit another crime. Also, if the prosecution suddenly uncovers fundamentally new, highly convincing evidence that totally flips the case, they can absolutely apply to have that bail canceled. However, don't panic. The 2012 case of Mohammed Aslam reassures us that judges don't take this lightly. The threshold for canceling bail is deliberately way higher than refusing it in the first place. Once you've secured your liberty, the prosecution can't just cancel your bail because they had a change of heart or want to harass you. No way. They have to bring hard proof of a specific, tangible change in circumstances, like an overt act of witness intimidation. Because at the end of the day, securing bail under Section 497 is simply securing your liberty while you wait for justice. Bail is a guarantee that you will appear in court. It is absolutely not an acquittal. You've won the battle to sleep in your own bed, but the real fight in the courtroom, that's just getting started. The question is, are you ready for trial?